Today we're going to discuss an issue that we have covered before on Rochelle's Daily Wire video edition. Basically, the topic or the question is sitting on your hands a violation of the automatic stay? There is an existing split of circuits, and it looks to me as though it's getting deeper. It is a subject that the U.S. Supreme Court needs to resolve. Essentially, the issue most often arises in a Chapter 13 case when someone's automobile has been repossessed before that person files a Chapter 13 petition. The question is, must the lessor or the lender give back the car immediately after being notified that the debtor has filed a Chapter 13 petition? There are 5 circuits which have held that if you don't give it back automatically, you can be held in contempt, and that can be painful, shall we say, in a monetary sense. However, on the other hand, we have first the District of Columbia Circuit, and more recently, in February of last year, the 10th Circuit held that you don't have to give it back, that doing nothing is not an act to maintain control of property, and it is therefore not subject to the automatic stay. Well, guess what? Just about a week ago, the district court in New Jersey, in Camden to be precise, affirmed the bankruptcy court and held, along with the minority, that there is no requirement for a lender or a lessor to give back an automobile automatically on the filing of a Chapter 13 petition. I certainly hope that this issue goes to the Third Circuit, and that will enable the Third Circuit to weigh in, although I'm not sure that the Third Circuit is going to give us an answer before perhaps the U.S. Supreme Court gets an opportunity to address the subject, because the 10th Circuit's original case in February a year ago was called Cowan. The 10th Circuit issued another decision in the middle of October, October 17 to be precise, in a case called Garcia, where they upheld Cowan and said no, the automatic stay does not require you to do something. You can just sit on your hands and not give the car back. I'm pretty sure there's going to be a certiorari petition filed in the Garcia case, and that, I hope, is a case that the Supreme Court tackles, because it would be very good to have an answer to that question. This is Bill Rochelle, Editor-at-Large for American Bankruptcy Institute, signing off until same time next week. And in the meantime, as I always say, don't work too hard.